It's to my understanding, sir, that many people do not need to remove their hat.
I'm asking about your situation. Explain it to me.
Yes, I believe mine is similar because spiritually, I believe I lose power when I expose my head fully. So I prefer not to remove my hat because I feel like I need power.
Put you down, you know, you're 19. Do something with your life. Don't become a statistic.
In here.
All right, leaves Mr. Richmond's two cases, 24M, 2519, 25M, 1312. Mr. Richmond, come on up, join your attorney, please. Mr. Richmond, would you please remove your hat in the courtroom?
Like I said earlier, Your Honor, I'd prefer for spiritual reasons not to.
Not cultural reasons.
Cultural are spiritual reasons, are they not? Or spiritual are cultural.
Would you describe that to me further?
It's to my it's to my understanding, sir, that many people do not need to remove their hat.
I'm asking about your situation. Explain it to me.
Yes, I believe mine is similar because spiritually, I believe I lose power when I expose my head fully. So I prefer not to remove my hat because I feel like I need power in here.
Okay. I'm going to order you one more time. I do not find that persuasive. In fact, I find it manipulative. I'm going to order you one more time to remove your hat out of respect for the court as I order anybody else so as not to treat you differently. I do not find your reasons to be persuasive. I'm going to order you to do it. And I just wanted to let you know that failure to comply, I will find you in direct contempt of court. Do you understand that?
As long as you understand, you're asking me to yield my power spiritually in a literal sense. This is what you're doing. This is what you've done last time. This is what you guys always do. And, you know, I think that's really...
I don't understand your answer. I'm ordering you to remove it again with you understanding the consequences. Do you understand the consequences of failure to remove your hat?
Can you please explain them?
Yes, I will hold you in direct contempt of court, finding that after repeated warnings, you failed to comply with the court's order and that it undermines the dignity and the authority of this court. And specifically, I don't find your reason to be persuasive. Do you understand?
Not fully. So do I
So
get to wear my hat next time? That's what I'm trying to understand.
I'm talking about this time. We'll worry about next time. Do you understand that if you fail to comply, I will hold you in direct contempt?
So I'm going to be held for 24 hours while it's cold out?
I have no idea what the consequences are going to be. You will be sentenced on direct contempt, and I'll allow you to make any statement you want in mitigation. I'll hear from your attorney as well, and then I'll decide. You may not go into custody at all, or you may, or there may be some other consequence.
Okay.
What is your response to my final order to remove your hat?
Sir, I really insist on this, and I feel really strongly spiritually about it, and it's time for me to take the consequences of that.
The court has now find that the defendant has been warned multiple times to remove his hat. He's been given sufficient notice and given a direct order, in fact, to remove his hat. He is explained, and the court finds it to be completely incredible, having even changed his explanation after talking with his attorney, explained his heartfelt, that's with air quotes, reason for not removing his hat. I find it to be incredible, manipulative, and in direct contempt of the court. I find that it undermines the authority and undermines the dignity of the court. I find that he does so intentionally. And because of that, he is in direct contempt. Regarding the sentence, and I will sentence you in a moment, but let's take care of the pretrial readiness conference piece first, and then we'll talk about the sentence. Anything else on the trials?
No, Your Honor.
All right, that leaves the contempt. Regarding contempt, Ms. Volkowski, do you want to be heard, or you want your client to be heard, or what would you like to do?
One moment, Your Honor.
Yes.
Your Honor, unfortunately, I don't have anything to add to the record.
Okay. Mr. Richmond, you're given the opportunity, and you can just stay right there, to tell me anything you want before I decide on the sentence or the direct contempt. If you want to say something, you may. If you don't, that's fine too.
I don't want to say much, but I mean, all there is to say that it's like a religion to me. It's personal. It's semi-parallel to what a lot of religions and cultures believe. And if I embellish too much, then that would be, I believe, wrong.
If you embellish, mean add more to it?
Yeah, like that is part of my belief.
Okay, I got it.
And that is part of, call it spiritual, religion, cultural. I don't care what you call it.
Okay. Thank you. I'm not going to call it anything. I will note that you are wearing a traditional black winter hat that shows no signs of any cultural or religious affiliation, nor have you identified any other than a personal belief that you would like to wear a hat to maintain power. Again, I don't find that to be persuasive, as I've already said. Court, again, finding the defendant to be in contempt, direct contempt of court. I'll sentence you to 1 day in the Boulder County Jail. I was considering longer, but I just need to communicate to you that you can't do this, so I don't want to keep you in jail longer. Plus, it's a snowy day, as you said. Perhaps it's not all that punitive based on what you said. So I'll sentence you to 1 day in the Boulder County Jail. Deputies, please. My bigger concern is that we're going to have a jury on Tuesday. I would encourage you to reevaluate your position, because I do not want you to wear a hat in front of the jury and be be in direct contempt again. I don't want that to be disruptive, because here it's just us, but that has the potential to be significantly more disruptive to the proceedings. You don't have to say anything about it at all. I just want to put you on notice that the rules remain the rules. You could talk to Ms. Bukowski about it if you want. You could say something too, but I just might be better to think about it and then talk to Ms. Bukowski. Yes. Yes, thank you.
As far as I recall.
Deputy, yes, Deputy, Mr. Richmond, he's going into custody.
Just wait for me, please.
He's been very cooperative with me, other than the contempt piece.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod. All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
What's Goodish, one county prosecutor?
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today? Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. So I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time? Yeah, Your Honor, that'd be fine. Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense? Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence. I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here. I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you. Thank you. Ms. Gooder's people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case. So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority, and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
What is your name, sir?
Whitlock.
Whitlock? All right. Mr. Whitlock, you have appears to be duplicate charges. So some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not proceed to I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am, I don't consult to the proceedings, and I would like to say things like, I already know how it goes. With the things about crossing guard lines, I'm in a boot, and I was with the officer the whole time. I told them they need to use their cameras here because they found a bud of weed in my boots.
Mr. Whitlock, you say you know what's going on, so you know this is being streamed live. So you
I
don't,
know, but that don't say I'd rather be charged for that than what they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, "Man, this gonna get thrown out," because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here, so when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings, though, and I do not accept the terms, like,
Okay,
yeah,
well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man. So
Okay.
that with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, like, I thought I had to deal with Fulton County on that instead of Clay.
Looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like,
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park,
ma'am.
it is on or around July 28th it happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clayton County?
Yeah, the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking. Because I know that's gonna get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not worried about it. I know there's BS. But it's like this one thing. Those charges that I have in Fulton County, those warrants, I had got locked up in front of the Legends on Old National. I know this not, I just want you to understand. I got locked up in front of the Legends on Old National. I have 2% in the Legends. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen I was clear up good, I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm going to stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and explain.
I need some professional help. Like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you can tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are.
You say, talk to my lawyer, right?
Yep.
And even if I say I demand a bond immediately.
What's your name, sir?
I am more
Moore?
special representation. I'm asking you.
Your Honor, his name is Tyrese Breland.
Breland?
That's
Yes,
not my
ma'am.
name.
Oh, Breland.
That's not my name. I am more. I'm here on special representation. I'm asking.
Same as last defendant, Your Honor.
My honor. I'm asking.
Okay.
What is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your.
So, deputy,
Yes, ma'am.
I would like to know your
so
nationality. I
he
would like-
has charges in jots and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
Asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor,
Is he deputy?
status
Say it
of
again, Your
everyone in the
Is
courtroom.
he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is mental health, or do you think it's just a sovereign citizen?
Can you provide me with the information?
Both. I think it's
Okay.
Can you provide me with the information?
All right, so I'm going to give you your charges.
Charges for what? Are you a U.S. citizen? Are you a U.S. citizen? My honor, are you a U.S. citizen?
Sir, be quiet.
Are you a U.S.
Yo.
citizen?
I said be quiet.
Are you
Be
a
quiet.
US citizen? What is your name? What is your status? What is the status
Yo,
of everyone in the
chill.
courtroom? That's what I'm asking.
All right. So y'all just go ahead and take him back. I'll just go ahead and put the bond. Y'all take him.
Feet up.
Asking
Move your
for
feet.
the court to be a jurisdiction of the court.
You might want to chill out.
I'm challenging the jurisdiction of the court. I'm challenging the jurisdiction of the court because I am not who they say I am. I am challenging the jurisdiction of the court.
No.
Everything should be challenged. I'm challenging the jurisdiction of the court.